Oof, Donald Trump just got hit with a lethal order from Judge Kathleen Williams in the Southern District of Florida in that case where he sued the IRS and the Treasury Department for $10 billion, then dismissed the case, which was assigned to this federal judge, Kathleen Williams, and didn't tell the judge that there was a settlement that was reached right around the time of the request that the matter be dismissed with prejudice, where Trump, in his personal capacity, sued the Treasury Department and IRS, and Judge Kathleen Williams, when she allowed the case to be dismissed, noted that there was no representations of any settlement agreement. But then Donald Trump, the IRS, and the Treasury Department prepared documents talking about a settlement agreement. They prepared a settlement agreement and said it was in connection with the case. They cited the case number of Donald Trump versus the IRS using the judge's initials, as if the federal judge gave her stamp of approval of the settlement, or at least that the settlement was done under the auspices of the case, which is in direct contravention to what was represented to this federal judge. So these dozens of federal judges, 35, 36 federal judges, brought a motion under something called Rule 60 of the Federal Rules of Civil Procedure, which is a rare rule to even cite, and said, Judge, even though this case was dismissed with prejudice in your courtroom because Trump, as the plaintiff, said, let's dismiss the case with prejudice, there seems to have been a fraud on the court that was committed. And even though it's unusual for non-parties, in this case, 35, 36 retired federal judges, to make a Rule 60 motion to reopen a federal case once it's dismissed with prejudice, under the most extraordinary of circumstances, circuit courts throughout the country have recognized that a non-party can bring to the court's attention a fraud on the court, a crime essentially on the court. And the judge in this case, Judge Kathleen Williams, said, you know what? I do have investigatory authority under Rule 11, and it does seem that it's possible that my court was used for misconduct, because the judge cites something called Rule 11. Rule 11 is when there is like egregious misconduct taken, where the judge has this, sanctioning authority under Rule 11. And the judge says, you know what? I do have power under Rule 11 to conduct investigations under my inherent authority if there was collusion, misconduct, if there was a fraud that was committed on the court. And what I want to hear preliminarily is I want the plaintiffs, I want the parties here to respond to me and tell me what happened with this settlement agreement. I want to now learn what happened here, because what seems to, we all know this is what actually happened. You filed a $10 billion lawsuit so you can say that you were in court. Then you dismissed it with prejudice, intentionally concealed from this court that you were going to use this case to then enter into a completely unrelated $1.8 billion settlement to create a slush fund for January 6th insurrectionists. You've abused this federal court forum to engage in this collusive settlement. And the judge says also, this probably violates numerous rules governing the Department of Justice. There's a footnote in the court's order that says the Justice Department isn't allowed to enter into like ancillary settlements that have nothing to do with the underlying matter. You can't just freelance and come up with things with that are completely unrelated, to the case, without at least going through certain steps. And so, it was interesting when I read this motion that was filed under Rule 60 by these federal judges. A lot of people were out there saying, well, these people aren't in the case. They don't have standing. And I said, got to read. One of the things I would always tell associates who worked for me, when you're a lawyer, you got to have a hard ass. You got to sit down and sit there, and you got to read the documents and read the footnotes. And when you read what those judges, very experienced former federal judges, were saying, They said, we know we don't have standing. We don't have to have standing. We're saying under Rule 60, we are non-parties bringing to the court's attention a fraud on the court. And alternatively, we're asserting ourselves as an amicus brief so that we are just alerting you to the fraud. And the court's like, thank you for alerting me of this fraud. I now want to hear from Trump. I want to hear from Trump's lawyer. I want to hear from Treasury. I want to hear from IRS. And they said, there's going to be big trouble on this for a lot of people. And by the way, there could be big trouble for Trump on this one as well, because it's outside of the absolute immunity. He filed this in his personal capacity. Trump's lawyer could be in big trouble. I mean, I'm talking about as big of ethical trouble as you could potentially get in as a lawyer right here. Anyone in the Treasury Department who's been involved in this IRS, Todd Blanche right here. And now you make some connections. This is precisely why the Treasury Department General Counsel immediately resigned when this thing was announced, precisely for this reason. Whoa, 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 do not drag me into this. That was prescient right there. One other thing, there was don't confuse, this is Judge Kathleen Williams, who was the judge in the underlying case, that $10 billion case that Trump filed against the IRS. Separately, there were a group of people who filed the lawsuit to block the slush fund from doling out any money pending an assessment of the slush fund. Separately, I believe it was a federal court in Virginia made a ruling blocking for now that slush fund from being used. So you have these back-to-back rulings. Earlier in the day, the ruling from a federal judge in Virginia blocking the slush fund from actually sending money out until an assessment of this fund. And then separately, Judge Kathleen Williams saying, oh, you tried to use this courtroom for collusion and fraud. It seems, let's start conducting an investigation under Rule 11. I want to, Harry, it's great to see you, but this is, I want to emphasize how big of a deal this judge's order is, because people may not have been paying attention to this part. This is huge.
100%. I think you said it right in your first word. Oof! This is big stuff, Ben, and it's a kind of double-tracked judicial response and pushback, one to the settlement and the slush fund itself, and the other to the bogus way in which it was executed. Let's start with what you focused on the most in Judge Williams. She's the one who has been deceived here, or at least that's what's going to be determined. She's the one who orders. I want to hear, is this a collusive case or not? Remember, she appoints a very high-powered group of 3 lawyers, and I think they're going to remain involved here, by the way, to explain what's up. Is there collusion? And they come in and say, looks pretty strong, and then boom, as you and I had predicted, to get out of answering, because they were between a rock and a hard place. Do they say, well, yeah, there's collusion. Trump tells us what to do. That means the whole thing is unconstitutional. Do they say, well, there's no collusion, we're fighting hard, and that's a joke, and we know it next to what they've done elsewhere? They took the third way, tail between their legs, and voluntarily dismissed. And she was chagrined, and that came through in her motion, saying there's no settlement, but I guess I have to dismiss. Don't really have a choice, until these 35 judges came in, some pretty eminent judges, starting with Michael Ludig, saying you do have a choice, and Rule 60 is your choice. And Rule 60 is this rare, narrow channel for reopening supposedly settled cases, when basically it's what the lawyers call void ab initio. From the start, this was bogus, because you never had jurisdiction, it was collusive and the like. And look, what's going on here is this whole effort's been illegal in 6 different ways, including the collusion, but they think they can get away with nobody being able to challenge it. That's where this other judge in Virginia comes in. I'll be right back to that. But Williams now, as I said she would in a Substack, goes running with this suggestion from the 35 judges, and now, you bet, DOJ lawyers and Trump lawyers are on the hot seat. It's Trump lawyers who have to answer first, and gives she's put it right out there, what she calls, in the opinion, grievous allegations that basically they just used her and to have a kind of a fraud. And exactly as you say, they then went and took this very case, put it at the top of the caption of the settlement agreement, and made it look for all the world like, even as ridiculous a deal as it might be, they're formally settling this worthless lawsuit with no jurisdiction in return for, $2 billion or so between the fund and the get out of jail free card on that Trump gets on the tax audits. And she's now saying, you got some splaining to do. Now, I do want to emphasize, Ben, what she can do. She can impose sanctions and up very high. She can do an inquiry. What the hell happened here? She can hear from the amici and say this was all collusive. And that's big stuff in the overall kind of growing momentum, including among some Republicans, to push back on this thing. The move that you can expect, however, from the DOJ and Trump is to say, okay, fine. The suit is gone and we can't use or purport to use this fund. We're doing it anyway, and come and stop us. So in other words, the motion she has before her doesn't give her the means to put the brakes on the whole thing, but it does give her the means to be very harsh toward the Trump himself and his lawyers. They've got to come in first with their briefing, and then the DOJ have a week until they have to answer. And she's definitely going to put them on the hot seat now. They may, this is the DOJ and Trump kind of MO, move for emergency relief, but the Fourth Circuit here, which is above Williams, either fourth or fifth. It's not like the DC Circuit. We do not know. We can't count on them to say, and it is the Fifth Circuit. You know, there's some pretty pro-Trumpers on that court. It can be kind of nutty. Look for them, the administration, to try to wriggle out of Williams's grip, and she's got a tight one and a basis to do it. Really, there should be no basis for a court of appeals to come in and interrupt a totally legit inquiry about was there fraud on the court. But you'll see some kind of emergency crying of wolf like the administration does. Even so, what's before Williams is some powerful stuff to really push back. Back to Virginia, which is the Fourth Circuit above. You had Judge Brinkema take a lawsuit that, like the other three that have now been filed, it's an uphill battle on standing. You've got a couple people who said, if you give this money to the Proud Boys and Oath Keepers, they're going to come after us. That's sort of the same thing as the Capitol Police said. And then you have a couple people sort of ingeniously, including an AUSA from Virginia, who said, hey, we're the victims of weaponization by the Trumpies, and you're giving a special kind of place to the January 6 types, and that's because of a disfavored viewpoint that we have. I just want to tell you that I don't know if that's going to make it for standing, but now take a step back. And what you have is the sort of combined efforts of judges and members of Congress. I spoke with Jamie Raskin earlier today, who's kind of in the epicenter, and he has clearly stepped on a hornet's nest. And it's going to be at a minimum a political conflagration. And is Trump going to say, I don't care? He's been doing a lot of things lately that are politically counterproductive because he seems to just want to, continue to stroke his base, his diminishing base, and the like. So again, the big development is with Judge Williams, and she has the potential power and ability now to really put both Trump and the DOJ's feet to the fire. I think you'll see the DOJ try to get out of it by calling emergency to the court above. And that's just one thing going on now. There are also in Congress and in the courts efforts to get at directly the totally bogus slush fund, which, as I say, has all kinds of legal infirmities, and the administration is trying to sort of brazen it out by saying nobody has standing to bring the claim. So two really different, important kinds of bases of operation against this huge stink pot. And all in all, I think it's going to build it's a kind of a fire. And the question is, will Trump try to walk through anyway and make it happen and dare people to impeach him or whatever? A flagrant violation of his take care responsibilities under the Constitution. Say, what's the ultimate remedy for that? Impeachment. We'll see where the Dems go with it. I just spoke this morning to Jamie Raskin. He's pretty hot and bothered about it with good reason. But with this now sort of double tracked, Williams and what they did before, and Brinkema and a few others, and why it's illegal now, this ain't going away.